Good morning. This is Heidi Meyers, immigration attorney. Today is October 1st, 2020, and there's been a lot of good news in immigration this week, so I'm just going to give you a little update. First is the federal district court case, ILRC versus Wolf. The federal district judge issued a preliminary injunction. Now, a preliminary injunction is a temporary order while the case is pending, so this is not permanent. The judge ordered that USCIS not implement the new rule on filing fees. As you might know, USCIS had a new rule on filing fees that was supposed to go into effect tomorrow, October 2nd, 2020, and the filing fees would have been significantly, hugely increased for naturalization, work authorization for asylum applicants, and in many other categories, it would have increased the filing fees. So the judge looked at the effect that this new rule would have on low-income immigrant populations, that this would have a terrible effect, that it would block the path to citizenship, that it would have a terrible, terrible effect on low-income immigrants in terms of obtaining immigration benefits. Now, even though the judge's opinion focused on low-income immigrants, the judge's order prevents USCIS from implementing the entire new rule. That means it doesn't matter if you make $500,000, it doesn't matter if you make $1 million and you have some employment-based petition, the entire new fees rule is banned for the time being. Now, another aspect of the new rule that will not go into effect because of the judge's order is the new rule on premium processing and how much time USCIS can take. So up until now, if you pay the fee for premium processing, USCIS is supposed to adjudicate or at least review your application within 15 calendar days. So 15 calendar days is 2 weeks. And the new filing fees rule would have changed the time to review premium processing cases from 15 calendar days to 15 business days. So 15 business days is 3 weeks rather than 2 weeks. So since the filing fees rule included that as well, we're sticking for now with the same premium processing rule of 15 calendar days, which is the 2-week rule. Now, the other good news this week is that part of Congress's continuing resolution to fund the federal government up to December is included a new act which will provide premium processing for all employment-based petitions. So for EB-1, EB-2, EB-3, all employment-based immigrant petitions are now eligible for premium processing. However, it increases the filing fees from the current $1,440 to $2,500. So for example, EB-1, multinational managers and executives are now eligible for premium processing, but they may have to pay up to $2,500 for that, and USCIS would have to adjudicate their applications within 45 days. National Interest Waiver, EB-2 applicants also become eligible for premium processing. Another aspect of the Act is that it provides premium processing for changes of status and extensions of stay to most of the non-immigrant work statuses. So you can now get premium processing not only for H's, but also for E's, treaty investor, treaty trader, L's, specialized knowledge worker, multinational manager, O, aliens of extraordinary ability, P's, and also R, religious workers. So It expands the categories of non-immigrant workers eligible for premium processing and provides a cap of fees of $1,750 for premium processing, and that if you pay the premium processing fee, your case has to be adjudicated within 30 days. So that is also a good news. Another fantastic news, if you are an international student, a foreign student, is that the new bill provides that changes of status to F, international student, J, exchange visitor, and M, vocational student are all now eligible for premium processing at a maximum fee of $1,750, and that USCIS would have to adjudicate your change of status to student within 30 days. Now that is like a great news, because international students had been having a real problem with USCIS. Young people would come here on a B tourist visa and try to change status to F1, international student, and USCIS would sit on the application for months and months. They would not be able to start school. So school starts in the fall semester, they would miss their fall semester, and then hopefully USCIS would get around to adjudicating the application before spring semester started. Now, you can pay the premium processing fee and your application will be adjudicated within 30 days. This also is great because the other problem with USCIS sitting on international students' applications for such a long time is that they also had the policy of finding these poor young people out of status. So if your B status ended, say, in October, and you filed for a change of status to F1 student, so you could start the semester in September, and USCIS was sitting on your application, and then finally you got it approved, say, in December for the second semester, by then you would be considered out of status because your B would have been expired and your F would not have started yet. So it was putting international students in a terrible predicament. So this aspect of the act is really great because now international students are going to be, and exchange visitors are going to be able to change their status in a timely manner. They're going to be able to start classes on time when the semester begins, and they won't have to fall out of status. Another great news is that premium processing is now available for all work authorization applications. So all work authorization applications, it doesn't matter the basis. You could have a pending adjustment with an employment-based petition. You could be applying for work authorization because you're married to a U.S. citizen and you have a pending adjustment. You could be applying for work authorization, say as an H-4, the spouse of an H-1B, or you could be applying for work authorization based on DACA, based on TPS, based on asylum. And if you pay the premium processing fee, your work authorization will be adjudicated within 30 days. Now, the maximum for the EADs that USCIS is supposed to charge for work authorization is $1,500. The new act also provides that these fees can increase, the premium processing fees, every 2 years based on the CPI, the Consumer Price Index. Basically, they can be indexed to inflation. The act also provides that USCIS has to develop a 5-year plan to go online, basically to go have electronic filings, accept filing fees electronically, and to notify petitioners, beneficiaries, applicants by email or notify them electronically. So, and they also have to report to Congress every 180 days, which is great. So this is the good news in immigration for this week, October 1st, 2020. I'm Heidi Meyers, immigration attorney, economic sanctions, international trade. I'm at 11 Broadway, Suite 925, New York, New York, in Lower Manhattan. We are conveniently located right near Battery Park, and across the street from the Museum of the American Indian, and diagonally across from the Wall Street Bull statue. You can call us at 212-791-4007 or 646-508-5225. My email is heidimeyerslaw@gmail.com. And don't forget to like this video and subscribe to my channel. All right, folks, everyone have a good day. Bye-bye.